Mr. Chairman. Thank you for the opportunity, members, to lay out House Bill 969. I'll preface this bill with saying this is probably the shortest bill I have filed in my short tenure here in the legislature, but it is a very meaningful piece of legislation. It's literally one paragraph. I'll warn you, one of the other bills I have will be one of the longest bills that I filed. But this bill simply talks about another option when a non-custodial parent is denied their right to possession. And so currently under Texas law, there's a provision in the Penal Code 25.03 that is actually a felony offense where a law enforcement officer can charge an individual with the crime of denying their children. I've been practicing family law since 1997, actually even before that, as a law clerk. So in my experience from 93 through 2023, which is what, a 30-year period, I've never seen a violation under 25.03 in the Penal Code ever occur. That doesn't mean it hasn't occurred in Texas. I've just never seen one. And I only say that to say this. This is a very good tool to have in the toolbox. This is a situation where if a non-custodial parent, a lot of what you've heard in the committee is if that's the father, if he shows up to get his visitation and he's denied, he will have the opportunity to call, and a police officer would actually be able to come out and issue a citation. It's a Class C misdemeanor, which is a fine-only offense up to $500. And I think in my experience, this would be a more meaningful tool. It would be more widely utilized. This is not mandatory. It's permissive. A city or county would be able to pass an ordinance that would propose a civil penalty for interference with child custody. I'd be glad to answer any questions the committee has. Otherwise, I would like the opportunity to close when appropriate.
Any questions of Representative Cook, members? I guess I was wondering, Representative Cook, would the police officer who shows up have to resolve factual issues or something, or would he just look at somebody has an order that says?
I think that's what you're going to see. I think a lot of times, Chairman, you probably have had the same experience at this state of the game. If a officer is called out, I think we all know that the officer is most likely going to say, call your lawyers,
yep,
go back to court, and that sort of thing.
Right.
So this bill was actually offered by Representative Raymond last session, and I was sitting on this committee, and at first blush, I didn't really think it was a great idea. But then after I saw the practicality, I really do think it's very effective, because I think it's a situation where if the custodial parent is denying visitation and a citation is issued, my guess is that that's going to stop there. So I think it'll be an effective tool, but it would require what you're talking about. I think it's going to be a situation where an officer is going to have an opportunity to read a court order and see what it says and make a determination. But that's what they do on almost any type of crime.
Right.
They talk to both sides. He said, she said, and make a determination.
Yeah, because I wondered if one parent says, we're supposed to drop the kid off at XYZ place. You weren't there, so I brought the child back home. Mm-hmm. Police shows up and says, well, it looks like you're engaging in something that's different than the court order says. He said, well, yeah, I had no choice. And what's the police officer going to do at that point?
Like I said, I think it's just a situation that the officers find themselves quite often, where they're just, they're going to have to do a little bit of investigation, ask some questions, and make a determination.
Okay.
Yes, sir. All right, thank you. I'm going to try to address just a few of the comments very quickly. I know we're short on time this evening, but this is local control. This does, as the last witness testified to, the mayor shall relates to whether or not they adopt. It's not part of the elements of the offense, and so it is whether or not a city or a county decides to do that. Another issue was whether or not the fine of $500 was too much. This legislation gives the city and counties an opportunity to assess a fine or actually create an offense of anywhere between $0 and $500. It's not automatically $500. It's up to $500, no more than $500. And Chairman, I think to your question, I think what I would say is, we always hear the possession is 9/10 of the law, and in this case, that's what we're talking about, is possession. And so I think the best thing that this bill will accomplish is compliance, and that's really what we want. That's what, as lawyers, as parents, as human beings, as people just trying to get things done in life, really what we want is compliance. And so when people go to court and they get a court order, they expect it to be followed. The judges expect it to be followed. And so whether this is a situation where a citation is being issued on the scene, like this bill provides, or someone in the alternative has to spend money and take it to court and seek an enforcement, I believe this is a much quicker and much more inexpensive option to enforce court orders. And whether or not there's jail time involved, I think a couple of witnesses talked about that as well. If you receive a civil offense and you don't show up, a judge can issue a second charge, which is a failure to appear, also can issue a summons or a warrant to have you arrested. Also, if you violate a court order in family court or in your divorce court, then you also can be thrown in jail for violating that court order as well. So lots of different options here. I just think this is a quick and easy opportunity to establish compliance, and I would ask your favorable consideration. I appreciate the opportunity to lay out House Bill 969, and be glad to answer any further questions.
Well, I was just looking